He's asking 4 simple questions. Number 1, why can't in-house counsel handle this case? Number 2, what conflict of specialization exists? 2, who approved the outsourcing? 4, what is the value for money? Explain first, spend later. Now, this case has not ended. Ladies and gentlemen, welcome back to another episode of Katiba na Chai. But before we do anything else, let's slow this story down. Because if you've been online, you've probably seen headlines saying, court bans government from hiring private lawyers. And if that were true, half of Nairobi would currently be asking, Siri, can I practice conveyancing in Kigali? But that's not what happened. So what happened in Nakuru is not an ending. It's a pause. And today's episode exists for one reason only, to explain what exactly was paused and why it was paused, and what happens next. Now, this case is currently before a high court in Nakuru. For those who like being specific, it's case number HCCHHRPET/00/2026. Now, the court issued what is called a conservatory order. That term means a conservatory order is the court saying, I'm not deciding who is right today, but I'm also not allowing business as usual to continue. So, no law has been struck down, no final judgment exists, and no advocate has been permanently barred. Okay, the court has simply said, stop spending for a moment, explain yourselves, then we proceed. See, this case has not just ended, it has just begun. This case was filed by surprise, Okiom Tata Okoiti and others. And here is the first twist. None of the petitioners are advocates. I'm not saying this to insult them. It's an explanation. A normal advocate would almost never bring this case, not because it's illegal, but because it challenges a system that pays advocates. So this case could only realistically be brought by people who are not themselves inside of the profession. Already, that tells you something. Now, let's look at who is being sued. The Auditor-General, the Council of Governors, national and county government entities. There are over 70 respondents in total. So this case is not about one rogue county. It's not about one ministry somewhere, about how Kenyan state hires lawyers. And this is why LSK is very interested. LSK is interested because this case goes directly to public sector briefs, advocate livelihoods, and the structure of legal work in Kenya. If the rules around outsourcing tighten, advocates feel it immediately. So when LSK pushes back, that's no drama. Ladies and gentlemen, lawyers are being introduced to economics. Now, let's talk about the judge. The conservatory order was signed by Justice Samuel Mohochi Mukira. Now, before becoming a judge, he was an advocate, but not the kind who built a career defending government agencies or waiting for state briefs to become comfortable. No. Most of his professional life was spent in human rights litigation, public interest cases, a lot of civil society work. In fact, he was often suing the state rather than representing the state. So when he looks at state legal spending, that judge is not asking, how do we keep this system comfortable? No, he's asking, where's the paper trail? And that context matters. Now, let's be precise about what the court actually ordered. The court temporarily suspended the engagement of private advocates, the procurement of legal services, the continuation of existing engagements, and even pending payments where public entities already have in-house legal officers. And crucially, the court directed the controller of budget not to approve funds for external legal services for now, which makes this very clear. This is not permanent, this is procedural. It's the court saying, explain first, spend later. And some lawyers have said, this issue has come up before, and they're partly right. This question has appeared in Parliament, in Auditor-General reports, has been touched on in some cases, in policy debates, and in committee hearings. But it has never been settled by a court like this. Those were conversations. Now this is litigation. This is the first time a court has frozen money first and then asked questions later. Nikubaya. And to understand why, we need to talk about the audits themselves. Now, brief context. Across years of Auditor-General reports, counties, ministries, state agencies, even constitutional bodies like IBC, the same problems keep appearing, especially around legal matters. There's some missing court attendance records, There are no signed contracts with law firms. Fee notes with no progress reports. There was no tracking of ongoing cases. Costs are escalating and nobody able to explain why. Now, I need to make this very clear. This is not about bad lawyers. It's about weak systems. And when systems are weak, money leaks quietly. Now, let's bring this home with a real example. According to the conservative figures reported by the Daily Nation and from the Auditor-General report, Nairobi County government alone owes tens of billions of shillings in legal fees. Not hundreds of thousands, not millions, billions. It is the part that should make you sit upright. The bulk of that debt is concentrated in just 4 law firms. 4. Meaning if Nairobi County were a WhatsApp group, those 4 firms would be the admins. And you see, this is not abstract money. This is taxpayers' money. This is money that was meant for roads, for health centers, for maternity wings, garbage collection, and development. Because legal fees are unpredictable, and litigation does not respect budget ceilings. Okay, those bills spill into the next financial year, and under the Public Finance Management Act, unpaid legal fees become pending bills, and pending bills are treated like debt. And according to the Act, debt must be paid first. So yes, legally, cleanly, properly, money meant for development cannot be diverted to pay lawyers for cases that already ended. Not because lawyers are villains, no. But because debt does not care about maternity wings. Now let's say the quiet part out loud. In litigation, you can lose, you can withdraw a case, you can get struck out, you can even embarrass yourself constitutionally. But the invoice still arrives. On time, confident, with headings. Winning is optional. But a lawyer billing you, that is guaranteed. Now, let's talk about in-house lawyers. Now, government in-house lawyers earn fixed salaries. They don't earn overtime or bonuses for saving billions, Meanwhile, one external brief to another lawyer outside can exceed their annual pay. And yet, what do in-house lawyers actually do? We hire them, then sideline them. They sit behind governors and cabinet secretaries looking serious, They help HR fire people. They write advisories that start with, this is for guidance purposes only. They attend meetings titled, for your information. And they also decide which external lawyer gets the real work. These are not litigators. They're like legal decor. So the state does something incredible. Skia him. It pays an in-house lawyer to fire someone. Then hires an external lawyer to defend the firing. Then it loses the case. Then it appeals. Then it carries the bill into the next financial years. Then it cancels a development project to pay that external lawyer who lost the case. Efficiency. Now, to be fair, LSK's argument is not stupid. They say public beefs sustain advocates, and some cases require specialization. In-house offices are overstretched, so a blanket freeze risks paralysis. And those are serious points because we're not being anti-lawyer here. So what is the court really asking? Justice Mohochi is not banning lawyers. He's asking 4 simple questions. Number 1, why can't in-house counsel handle this case? Number 2, what conflict of specialization exists? 2, who approved the outsourcing? 4, what is the value for money? Explain first, spend later. Now this case has not ended. It has just begun. And for the first time, how the state hires lawyers is being questioned slowly, publicly, and under oath. In government litigation, winning is optional, but billing is guaranteed. And accountability is finally on trial. This has been Katiba na Chai. Don't forget to like, subscribe, and share. Because sometimes the law poses things so the rest of us can finally understand what is going on.